Thank you very much for joining us today for Hunton's webinar on managing cybersecurity governance in the boardroom. I'm Lisa Soto, and I head Hunton's top-ranked global privacy and cybersecurity practice, and I also serve as the chair of the Department of Homeland Security's Data Privacy and Integrity Advisory Committee. Before we begin, please note that our program is being recorded, and we will provide everyone with a link to listen to the recording at a later date. If you have any questions throughout the program, you can use the chat feature on your screen to type your questions. And if we have time at the end of the session, we will address your questions at the end of the program. I'd like to introduce our additional speakers for this session. We have with us Scott Kimple, who is a partner in our Washington, D.C. office. Scott has in-depth knowledge of SEC policies, procedures, and enforcement issues, and he regularly advises clients on matters involving securities laws, M&A, and corporate governance. Prior to joining Hunton, Scott served on the executive staff of the SEC as counsel to Commissioner Troy Paredes from 2008 to 2012. Next is Brittany Bacon. Brittany is a partner in our New York office. She has assisted many companies on data breach and cyber incident response. She focuses on helping companies to manage privacy and information security risks. Aaron Simpson, who many of you know, is resident in our firm's London office, and he leads the firm's European data protection and privacy practice. Aaron is well known as a top privacy professional. He's been recognized by Chambers and Partners, Computer World, New York Super Lawyers, and the Legal 500 as such. And finally, Walter Andrews. Walter is the head of the firm's insurance coverage practice, focusing on complex insurance litigation and specializing over the last few years in particular on cyber insurance. As you all know, cybersecurity is clearly recognized now as a fundamental risk issue for companies. And this means that boards have oversight responsibility for cybersecurity, and management needs to ensure that boards are kept apprised of cyber security risk and incidents. And certainly management needs to focus on the issue from a strategic governance perspective. Today we're going to look at the issue of cyber risk from the lens of the board. Next slide, please. Just to give you a sense of our perspective, we have 35 privacy and cybersecurity professionals around the globe in the U.S., in Europe, specifically London and Brussels, and in Asia, in particular Beijing. We represent clients across industry sectors, so we have a very, very strong perspective across industry sector. For those of you who are not aware of our Center for Information Policy Leadership, it's a privacy and security think tank that is associated with the law firm, really having a huge impact, especially now in Europe with the effective date of the GDPR just having passed, in shaping policy really in Europe, in Asia, and in Latin America, as well as the United States. If you are not a subscriber to our privacy blog, I would commend it to you at www.huntonprivacyblog.com, and if you tweet, our Twitter handle is listed on this slide. Next slide, please. Today we're going to talk about the role of the board. We're going to start with the role of the board in cybersecurity, and then we'll turn to what the SEC is doing in this space, which is really quite extensive now. We'll talk about how to manage these issues in M&A transactions, and of course hit on, because no session on privacy would be complete these days without hitting on EU issues, which are just so top of mind right now. And then Walter will bring up the rear to talk about cyber insurance, which is the backstop really with respect to liability in this area. And then I'll come back to you and talk about some proactive measures and lessons that we've learned in this space. Next slide, please. There's really no question now that the board sets the tone and the direction of the company with respect to cybersecurity. And this issue really came to the fore for boards of directors following the Target breach when one of the commissioners of the SEC cautioned that boards that choose to ignore or minimize the importance of their cyber oversight responsibility do so at their own peril. So that was a very, very significant statement. And in its recent 2008 guidance, which Scott will provide details on shortly, the SEC made clear that a company must include in its SEC filings a description of the board's role in cyber risk oversight. There have been just a few judicial opinions that have addressed the board's cybersecurity oversight responsibilities, so we really have scant insight into the level of oversight that is necessary to satisfy a director's fiduciary duties to shareholders. This is in part because the filing of a shareholder derivative lawsuit in this space is really a relatively new phenomenon, and typically any case that has come to the fore has been settled on terms that are favorable to the company. Some of the most significant cases to date involve data breaches at Home Depot, at Wyndham Hotels, and at Yahoo. And I'll talk about those in just a minute. But I think the key takeaway is that if a board provides appropriate oversight to the company's cybersecurity program, a court will be hard-pressed, really will be hesitant to second-guess the board's risk-based decisions concerning cyber controls and management. Just as an oversight, sort of as an administrative matter, boards typically will delegate responsibilities in this area to the audit committee. But of course, the full board retains full overall responsibility for this sort of oversight. And because of this, communication with management is absolutely critical. And just to give a sense, Wyndham's board met over a dozen times to discuss cyber issues, and the court found that to be a very positive feature. So important to present to the board and to ensure that the board is kept up to date on a very frequent basis. Next slide, please. So as I mentioned, there have been just a few actions in this space. The most recent was actually a securities class action lawsuit against Yahoo, and the company recently reached a settlement for $80 million, and this was allegedly for Yahoo failing to disclose data breaches in a timely manner and allegedly making false and misleading statements in the company's securities filings. PayPal also was hit with an action in December of 2017. Here a group of shareholders brought a derivative action in connection with a data breach at TO Networks. TO was a company that PayPal had acquired less than a year before this data breach came to light. And the allegation is that the shareholders suffered a reduction in the value of their equity in the company. The stock price fell 5.75%, and that the allegation is that there was significant loss to the company, and that's pending. We don't have the results. We don't know the results of that action yet. In Home Depot, this is a very interesting ruling. The court here provided probably the deepest analysis of all into the board's cybersecurity oversight responsibilities, and this was really the insight was found in a settlement of a set of derivative actions. The settlement amount was minimal; it was just over $1 million. But the settlement terms focused on establishing clearer roles and responsibilities for cybersecurity and mandating that the company implement certain key industry cybersecurity practices. And then finally, just to note the Wyndham decision, this is the Palkin v. Holmes decision from October of 2014. This was the first judicial opinion to arise from a shareholder lawsuit against a public company that suffered a data breach. So it was very important from that perspective. And in this case, the court sided with Wyndham and dismissed the lawsuit and indicated that the board had exercised appropriate business judgment in managing the data breach and refusing to bring further litigation against the company. And I'll just also note that boards have been in some of these cases threatened with ouster. So this is the ultimate punishment for a board, of course. In the Target case, 7 of 10 board members were threatened with ouster. There was an effort to remove the majority of Target's board, and this was, of course, a wake-up call for directors across the country, and was at least in part the reason that boards have become much more focused on this issue in discharging their duties. Next slide, please. So it's really important that boards focus on a couple of key issues, and we've listed them here. A board needs to understand what the company's crown jewels are, whether that's personal information, user information, customer information, or whether it is source code or financial information or intellectual property. But whatever it is, the board really needs to understand what the crown jewels are and how that data is being protected. And of course it deserves a higher level of protection and safeguards than other data might receive. The board needs to receive routine updates on key cybersecurity projects, on its priorities for the year, on budgets, and on overall performance, as well as receiving benchmarking reports. How are we doing vis-a-vis other companies in our space? Are we spending more? Are we spending less? Are we using the same technologies to try to prevent intruders from getting in? Are we using different technologies? So that's the kind of benchmarking, very high level, of course, but benchmarking that companies are doing, are giving to their boards. Typically, a board will approve an information security program annually, as well as critical initiatives, not the run-of-the-mill items, but some of the more high-level initiatives. And boards also are typically charged with ensuring that appropriate external parties are available and ready to assist in the event of an incident. So good to know who those external parties are well in advance. And finally, boards are charged with holding management accountable. This is, of course, a management duty to ensure that strategy is appropriately set in this area, and boards absolutely are very plugged into understanding that strategy. And some board members, some directors now are really quite savvy in this area, and boards are focused also on putting directors on the board who have some cyber expertise. With that, I will turn it over to Scott.
Thanks, Lisa, and thanks everyone for joining us today. I think Lisa's done a great job of describing the overall fiduciary environment that public companies in particular operate in when it comes to some of these cyber security issues. And that's important because the SEC doesn't really set those standards for public companies. They're much more concerned with disclosure around how boards are managing risk, how these events can impact their business, and the whole other range of risks that go along with that. So let's just kind of back up for just a second and talk a little bit about some of the history of what the SEC has been doing on the cybersecurity front for public companies. And then we'll spend most of our time talking about the guidance that just came out a couple of months ago from the full commission. So when I talk to a lot of corporate counsel, I think there's this misperception that the SEC is somewhat new to the cybersecurity game, or is sort of the new kid on the block and doesn't really understand these issues. And We can certainly have that debate, but the reality is the SEC has been in this space for decades, longer than a number of other agencies. And that's because of the Edgar database. For nearly 25 years now, public companies have been filing their periodic reports and registration statements through the online Edgar portal. That was a process that started all the way back in the 1980s when the agency started developing it. So here we have a federal agency that for the better part of the last 3 decades has been managing storage and reporting of huge amounts of online data. And they've learned a lot of lessons along the way there. Another big milestone for the SEC and the cybersecurity space is the Gramm-Leach Act that many of you are familiar with in other contexts. But under that law, the SEC, like a number of other financial regulators, was required to adopt the safeguards rule for certain kinds of regulated entities, broker-dealers, investment companies, stock exchanges. Now, those don't apply to most public companies unless you happen to be in one of those fields. But again, it's created institutional knowledge and learning really now for almost 20 years on those issues. When the cyber security phenomenon and the phenomenon around breaches really started to become something that was in the news every day, is when I think the agency started thinking about, all right, what should public companies be disclosing on these issues? And that culminated with some staff guidance that was issued in 2011. It went into some of the basic disclosure obligations that companies have, and for a regulated company, staff guidance is sort of what you follow. There's really not much difference between that and any other kind of regulatory pronouncement that comes out of the agency. But in the realm of administrative procedure law, staff guidance doesn't really have the same significance as something that would come from the 5 commissioners themselves. And so almost immediately after the 2011 guidance came out, there was criticism of the agency for the commissioners themselves not tackling the issue, and also quite a bit of pressure from Congress that was put on the agency. We have a new president now. We have a new SEC chairman who's been in office now for about a year and a half. And one of the first things that he encountered when he got to the SEC was the Edgar breach. I think that event, which happened last year, really was a wake-up call that maybe the agency should be doing more on this front. And one of the easy ways to score some political points with Congress after something like that is to say, well, we're going to clean house and we're going to release some new guidance. And so that's what the SEC did this spring, and I'll spend the remainder of my time talking about that guidance. And what it did, and it was significant because when the 5 commissioners speak with one voice on an issue, it's afforded a higher level of precedential weight by the courts. And under a doctrine called Auer, which is similar to Chevron deference, courts will respect that. So this is really another way of expressing what the law is on these issues for public companies. And the guidance broke down into several different areas, all of them around disclosure, around how boards and management and companies are tackling these issues. And so the guidance starts with describing the framework for materiality under the securities laws. It's the same framework that applies to any other disclosure issue. And the guidance provided some pointers on how cyber issues can become material and what are some of the things that companies should be looking at when they consider whether a cyber event rises to the level of disclosure. And it's the same basic analysis that companies have been doing for decades. So there's really nothing new there. But I think it is critical to point out that when you have cyber issues, they're treated like any other significant development at the company, and if they pass the materiality test, they would need to be disclosed. The guidance also went through, and in this respect repeated something from the 2011 staff guidance. It went through several sort of black letter law areas in Regulation SK and Regulation SX for companies as they're putting together periodic reports or registration statements. Areas to consider where cybersecurity disclosure might fit in. MD&A being a critical one, risk factors being another one. The business, litigation environment, even exhibits can sometimes come into play. Again, these are things that Disclosure Council deal with on a regular basis. In other contexts, and the Commission is reminding us that in the cyber world, they can also be covered and be relevant. One area that sort of is a subcategory of that the guidance went into is the duty to update and the duty to correct, which could itself be the subject of an entire CLE. But I think the takeaway there is the SEC is saying you can't go by on stale disclosures. And in particular, this is an area that is rapidly evolving. And when a cyber event occurs, disclosures can change very rapidly. And so companies should not just draft a risk factor and then sort of let it sit there and collect dust for 5 or 6 years. They should be constantly considering whether we need to update these things. And I think that's a good segue to the topic of disclosure controls and procedures. There was kind of a throwaway sentence on that topic in the 2011 guidance, but the new 2018 Commission guidance really points out that this is a critical feature and that companies, when they're doing their regular disclosure control review, whether it's through a disclosure controls committee or however else you satisfy the requirement to have disclosure controls and procedures under Sarbanes-Oxley and other statutes, you need to include folks who are knowledgeable about cybersecurity and information security and data privacy type issues. And that at some companies has been a shortcoming. This was an issue that was highlighted in the Yahoo enforcement case that Lisa will talk a little bit about later. But the Chief Information Officer, the Chief Information Security Officer, Vice President of Information Technology, whatever you call that person or people at your organization, need to have a seat at the table when you're preparing SEC disclosures, so that anything that they've learned in the course of their daily responsibilities is considered, and you, like any other bit of key information, you do the materiality test on it and the test as to whether it satisfies an affirmative SK disclosure obligation, and you decide whether to put it into your disclosure report or not. I think at some companies this is not the case, and the SEC is encouraging them to make sure that they change their policies and procedures to reflect that. Another area that the disclosure guidance focused on was insider trading. To securities lawyers, this is probably not a new development, but again, when you're looking at whether someone is trading on the basis of material non-public information in the violation of a duty to someone, certainly the existence of an undisclosed cybersecurity event could be material. And particularly if you're an officer or director or employee of a company and you trade on the basis of knowledge of either your own cyber event or a cyber event that occurred at perhaps a counterparty or a supplier or a vendor, then that conduct will be examined just like any other bit of insider trading. There have been a couple of recent SEC enforcement actions on this issue. There's been some publicity about executives trading ahead of cybersecurity, cyber event disclosures that companies have made. So again, the reminder here is when you're doing an insider trading analysis of a particular issue, once again, cybersecurity events are in the same category as an M&A or a financing or any other significant transaction that you would weigh in determining whether it's permissible to trade or not. There's a brief statement in the guidance about Regulation FD compliance. Again, there we can't make selective disclosure about material information except within the context of some of the exemptions that are built into Reg FD. And so I think as companies are responding to data breaches and they're talking to different constituencies, you have to run that through the Reg FD filter and make sure that the public is getting the right kind of information if that regulation requires it. I think in sum then, the guidance is really telling companies that, look, the SEC is paying close attention to these issues. We're going to be looking at how companies disclose this kind of information, what policies and procedures they have in place. And as we saw in Yahoo, when those policies, procedures, and disclosures don't rise to the level the SEC believes is appropriate, enforcement action could be relevant. With that, I'll say we can advance to the next slide.
Great, thanks, Scott. This is Brittany, and I will be speaking about managing cybersecurity and privacy risks in the M&A deal context. In today's business environment, it is absolutely critical for companies and for boards in particular to consider the privacy and cybersecurity risks and implications of their investments prior to an M&A transaction. And that includes in the context of purchasing, merging with, or financing a company, or even acquiring new talent and other assets. As we have seen in recent deal history, data breaches and privacy compliance issues can significantly reduce the value of an M&A transaction and pose integration obstacles post-close. Potential liabilities for data protection non-compliance, particularly under the new EU General Data Protection Regulation, which Aaron will speak to, are skyrocketing. Data protection regulators also are empowered to require companies to actually cease data processing activities altogether to the extent they are found to violate applicable law. And then beyond regulatory penalties and enforcement actions, companies can face steep contractual sanctions that stem, for example, from violations of industry standards like the payment card industry security standards. Through thoughtful due diligence efforts and a robust process for evaluating and mitigating privacy and data security related risks, companies can help prevent the incurrence of unanticipated costs and other criticism that may result from unforeseen information security and privacy issues that may emerge post-close. We work routinely with companies to establish these types of processes for identifying and addressing privacy and cybersecurity risks and potential liabilities in the context of contemplated M&A transactions. Now, this is all to say that the management of cybersecurity and privacy issues, at the legal level, at the senior management level, and at the board level should be built into the full life cycle of every transaction at the global level. Now, this slide includes a number of types of key documents that may be requested during the due diligence phase of a potential M&A transaction. Documents include privacy policies and notices in the relevant key jurisdictions. It may include information security policies and procedures, incident response plans, privacy and information security training materials, key contracts with service providers that the target may use to process personal information, documentation regarding risk assessments and other types of audits, and finally, documentation around data transfer. Even before you get to the due diligence phase, we're seeing companies attempting to manage the target's expectations and to establish the importance of privacy and data security risks at the outset of a potential deal. And companies are doing this by including in the term sheet key provisions that address data privacy and security considerations, including that representations relating to privacy and data security are fundamental representations, and that the target will be subject to extensive due diligence of its privacy and data security practices as may be appropriate. Next slide. Moving on to the due diligence phase. So in the due diligence context, various factors inform a company's privacy and data security diligence strategy. And those factors include an understanding of the nature, the size, history of the target, the type, sensitivity, and volume of data that's being processed by the target, the structure and cost of the company's investment, and whether there are any material data security incidents or privacy compliance issues that are ongoing or have occurred at the target. This slide includes a list of key due diligence questions, and this is just a small sampling of the various types of inquiries that an acquiring company would send over to the potential target. The relevant questions include things like what data does the company collect and for what purposes, with whom does the company share the information, and what contracts are in place to facilitate such disclosure. Where is the data stored, and how does the target manage any cross-border data transfer issues or localization requirements that may apply? What safeguards are in place to protect the data? What training is provided to relevant personnel? Importantly, has the target suffered a data breach or a cyber event, and is the response to that incident still ongoing? Has the target received any formal or informal complaints, or is it the subject of an investigation or audit by a regulator, court, consumer, or others? regardless of the type of transaction, a target's vendor management program is absolutely critical. Does the target have vendor contracts in place with privacy and security provisions? Has the target's vendors experienced any data breaches? One interesting survey, in a 2016 New York Stock Exchange Governance Services survey of public company directors and officers, only 26% of the respondents said that they would consider acquiring a company that recently suffered a high-profile data breach, while 85% of respondents claimed that it was very or somewhat likely that a major security vulnerability would affect a merger or acquisition under their watch. Turn to the next slide. In terms of documentation, so after the due diligence process, if the risks have been appropriately identified, mitigated, and/or accepted, the next phase is the contract negotiation phase. Deal documents should include relevant representations concerning the target's privacy and security practices. These reps, at a minimum, would address the target's compliance with applicable laws and industry standards. Some typical reps and warranties we see include something like, to its knowledge, the company is in compliance with all material aspects of privacy and data security laws. And to its knowledge, company has experienced no data breaches within the last 5 years, except for breaches listed in disclosure schedules. Acquiring companies also may require the target to conduct certain mitigation and remediation activities, like developing a data protection law compliance program or implementing certain safeguards to protect personal data. Finally, in certain circumstances, it may be appropriate to incorporate some forward-looking contractual obligations into the relevant agreements, certain covenants, to the extent the target is going to remain partially or fully responsible for the target's privacy and data security practices. Based on the type of transaction, acquiring companies may assess whether it's appropriate or necessary to impose post-closing covenants on the target to address remedial actions by a particular deadline. Next slide. And finally, in the deal context, when we look at post-closing activities and some lessons learned, particularly as it relates to boards, targets are absolutely well advised to make sure that their house is in order before even engaging in the due diligence process. Undiscovered privacy and data security risks can result in direct costs like legal fees and incident response costs, or indirect costs such as customer losses and reputational damage or drop in stock valuation. Key lessons learned: do the due diligence, understand the risks before entering the transaction, and then carefully craft appropriate terms in the deal documents to address the relevant contingencies. From a board perspective, boards have a duty of care in transactions, meaning boards must be informed and they must consider all material information reasonably available when making decisions, including decisions pertinent to a pending merger or acquisition. And finally, boards have a duty of loyalty, the duty to remain independent in transactions and to monitor risks to the corporation. Directors who fail to monitor and oversee known risks can be deemed to have disabled themselves from being informed of problems requiring their attention, which would thus result in a breach of their duty of loyalty. And I'll pass it over to Aaron.
Thank you, Brittany. So I'm going to talk a little bit about EU cybersecurity issues. Lisa mentioned in the introduction that this is fairly topical, to put it kindly. As a relative matter, from a cybersecurity perspective, regulation and enforcement in the EU is actually in its infancy compared to the U.S. Data protection law, more generally, has a very long history in the European Union, and data protection law is quite comprehensive and onerous. Certain EU member states have had breach notification requirements or cyber requirements for specific industries, but really with the inception of the GDPR here on May 25th and the NIS directive, which also is becoming effective at the member state level as we speak, it really is now for the first time we have pan-European cybersecurity obligations. From a board perspective, I think that it is really important to understand these new cyber obligations and how they can impact the business. because the impact can be significant. So all of you have probably heard of the GDPR, or the General Data Protection Regulation, which came out on May 25th. I think it's fair to say that it represents the most comprehensive and onerous data protection law in the world. It imposes obligations on all aspects of an organization's data processing activities. And from a board perspective, I think you've probably heard this, but it's important to know, that infringements of the GDPR are punishable by fines of up to 20 million euros or 4% of global turnover. So, depending on the nature of the violation, the stakes can be quite high. From a scope perspective, many companies are wondering whether this law applies to them. Well, it applies to organizations who are established in the EU. That one kind of goes without saying. But it also has extraterritorial application, meaning it can apply to organizations who are not established in the EU if they offer goods or services to people in the EU, or they monitor the behavior of people in the EU. There's a lot of terms of art and legal mumbo jumbo in those two statements, and so it will be important to you all, if you're not established in the EU, to really think through the application of the GDPR, and obviously we're happy to help you think it through. One very important aspect of the GDPR that is sort of the focus of today's conversation, cybersecurity, is what is required of a business when a quote-unquote personal data breach has occurred. Unlike the U.S. laws, there's no special definition of personal data for purposes of the GDPR's breach notification requirements. The term personal data throughout the GDPR means the same thing. And really that's any information that relates to an identified or identifiable natural person. This is very different than in the U.S., where you have different definitions of personal data depending on the nature of the law. And in the data breach world, you have special categorization of data to include name plus financial account number, social security number, things like that. The breach notification law in the GDPR is triggered by a breach involving personal data, which is the same term used throughout the GDPR no matter what issue you're up against, with minor exception for a sort of special categories of data. But for breach purposes, we're talking about plain vanilla personal data. What this means, importantly, is that if data indirectly identifies an individual or directly, then the data will be considered personal data. In effect, what this indirect identification means is that data can be personal even without a name if it allows you to single an individual out. When you look at the definition of personal data breach, this term is defined in the GDPR to mean a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data that is transmitted, stored, or otherwise processed. Importantly, this means that breaches go well beyond hacking types of incidents, include all kinds of events, such as breaches of confidentiality that could be caused by improper internal access, or availability breaches caused by ransomware. Right? There's obviously a lot of technical jargon built into these definitions of personal data and personal data breach, but I think the takeaway here is that the concept of personal data is extremely broad, and the definition of personal data breach is also extremely broad. So we're talking about a lot of incidents that could very, very likely occur. What happens if you've had one of these events occur? If you have had a data breach, the GDPR requires the company to provide notice to its data protection regulator, or regulators plural, at the member state level in the EU. So it's kind of the opposite of in the U.S., where the default is that you notify affected individuals, and in some cases you notify state regulators. In the EU, you notify regulators, and then in some cases, as we'll get into, you notify individuals. As a legal matter, and I think this is very important, so that you as board members understand, that your business has built incident response plans, notice is required within 72 hours of becoming aware of the breach, unless the breach is quote-unquote unlikely to result in risk to data subjects. As a practical matter, this is an extremely low threshold based on the now thousands of data breaches that we have worked on at Hunton Andrews Kurth. and the potential high fines that I mentioned, are going to result in an explosion, frankly, in the number of breaches that are reported to regulators in Europe. In addition to notifying regulators, companies are also required to notify affected individuals of the data breach if the breach is quote-unquote likely to result in a high risk to individuals. High risk is not defined in the GDPR, but it certainly would include breaches involving more sensitive data about the individual or financial account information that would allow access to an individual's financial account. The timing requirement for notice to individuals is more flexible, but it still needs to be provided without undue delay. This is a really important aspect of the GDPR, data breach notification, because for many companies, this will be the way that their data protection practices are put under a regulatory spotlight, right? You have a very low threshold. You're reporting these incidents to the regulator. It is conceivable, probably likely, in most cases, that the regulator is going to turn around and ask a number of questions about your GDPR compliance and your data protection practices more generally. So it is very important from a board perspective to understand, what sort of incident response plan the company has in place, and to understand, whether that plan has been practiced through tabletop exercises, right? And then to think even more broadly, right? The EU's one jurisdiction. Most companies are operating globally. How is that incident response planning taking into consideration different obligations in the U.S. at the federal and state level, in the EU, and then in Asia and other jurisdictions around the world, right? You want to be thinking about these incidents globally, right? Obviously, to do that, you need to understand the local law obligations, but you then need to sort of take it up a level of articulation and understand how to deal with these events globally, because unfortunately, most of these systems, are not impacted on a state-by-state or country-by-country basis, but these events are often global in nature, and so you have to have thought this through, which can be a challenge. As some of you may have experienced previously, it could also be the case that a company's service provider or vendor has a data breach with the company's personal data. Under the GDPR, in these cases, the service provider, or what is called a processor in GDPR terms, has to notify the company or the data controller in GDPR terms, and it is the data controller who has to notify the regulator and perhaps the individuals impacted as well. So there's no get-out-of-jail-free card when a vendor has a data breach. Timing is going to be of the essence, and so it's going to be critical to ensure that you've required a broad breach notification requirement in your vendor contract with very specific and, frankly, strict timing requirements. In addition to the GDPR, just to shift gears a little bit, in 2016, the European Union issued a directive on the security of network and information systems, which is also known as the NIS directive. This directive is more of a pure play cybersecurity law than the GDPR. I talked about the GDPR being more of a data protection or privacy law that has a cybersecurity component that is very important. But the NIS directive as a directive, and unlike the GDPR, where the R stands for regulation, the NIS directive is implemented at the member state level. That, as a practical matter, these member state implementations are becoming effective as we speak, and they have three primary goals. Right? The first goal of the NIS directive is to establish a framework at the local level in the EU to address cybersecurity issues. The second goal is to formalize cooperation across EU member states on cybersecurity issues because of the discussion we had previously, that these issues are often multi-state issues and very rarely limited to any one EU member state. And the third goal is to impose security obligations on operators of essential services and digital service providers, which includes breach reporting obligations. In the UK, where I sit, violations of the UK law that implements the NIS directive will be punishable by fines in keeping with the high fines imposed by the GDPR. Right, so cybersecurity in the EU, which was probably underrepresented from a regulatory perspective in the not so distant past, is now very much represented and has to be a key aspect of your business's considerations when it comes to data security. With that, I will turn it over to my friend Walter.
Thank you, Aaron. Talk about cyber insurance. I think that by now you should have learned enough from everyone else that you can understand that there's a lot of exposure here, and that one of the there are a lot of ways to sort of prevent it from a privacy perspective and a data protection perspective, but obviously we wouldn't be handling thousands of these if these breaches didn't happen. And one of the ways to fund the very high cost of these things is with insurance. And I think that boards who don't make sure that insurance is obtained are making a big mistake and creating some vulnerability for themselves. When we first started getting into this 5, 6, 7 years ago, there weren't that many companies that were purchasing cyber insurance. Now I think almost everyone is. I think if you have customers or employees, you need it. If you have any regulatory oversight, you need it. And we already now have the SEC and particularly the FFIEC, which is the interagency banking regulatory body, saying you better look into whether you can get or should get and how much you should get of cyber insurance. So people are getting it, and it's still very cheap. You can get the first $10 million of coverage if you don't have a horrible risk profile. You can get it for about $60,000, and given the cost we're seeing for these breach responses, that's a pretty good deal. The types of coverage you should obtain would be first party, third party, some kind of crime, social engineering coverage, and certainly D&O for the officers and board members. But you're also going to need to have both specific cyber policies, and you want to look at your legacy insurance products because we are getting coverage for some of them on some of the physical losses, some of the E&O type claims, and some of the crime coverage issues that arise. But I think it's most important that you actually take a very close look, as the FFIEC has suggested, at what coverage is there. I'm going to talk later about the gaps that we see in these coverages, but it's clear that these are still very new products. You've got a lot of carriers getting into the market who are very risk averse, who are worried that there have been thousands of breaches and will be quite a few more coming, and so they're being very reluctant to cover things. The brokers do not understand these products yet. It's not like products that have been on the shelf for many, many decades and they get pulled off for the right industry segment. If you're looking at a fire policy or a flood policy or the like, these are very specialized, and as I said, the carriers are really being reluctant to cover a lot of things, so you got to be very careful in what you look at. And we spend a lot of time working with companies, often because the board have asked us to do so, to make sure that the coverage is as robust as possible. What does cyber insurance cover? Probably the most important thing is on the first party side, it covers the breach response activities, the forensic investigation, the notice obligations, the remediation, and the business interruption, which is something that's often overlooked, but maybe the biggest issue in terms of exposure. If you're an online retail company, we've had some clients that have lost tens of millions of dollars. If you may recall, Jones Day law firm, which is one of the 2 or 3 largest law firms in the world, was shut down for quite some time and supposedly lost tens of millions of dollars. So, business interruption is a big issue. On the third party side, there are plaintiffs' lawyers who are very aggressive, who will bring lots of cases, and the settlements can be very expensive, as we saw with Target as an example, and the coverage can provide both defense costs and settlement fees for that. Government agencies can have pretty high fines and penalties. Aaron just talked about the potential 4% penalty from the GDPR. It's a little tricky how those can be covered, and it depends partly on what jurisdiction you reside in and the choice of law that may apply, but that's something that can be covered and certainly should be looked at. The hybrid coverages, a lot of times we're getting coverage through the E&O policies, particularly technology E&O policies, where we can get some cyber coverage, and for the social engineering fraud, we can do it through the crime policies. So we want to look at not just specific policies, but how they overlap. And of course, you want to have D&O coverage to cover both the officers and the board, and want to make sure there's no cyber exclusion on that policy. The biggest problem is, as I said, these policies are not quite as robust as we'd like. Carriers are wanting to see what kind of loss experience companies are having. They're going to see the cost of things like GDPR regulations and fines. They want to see what the business interruption losses are. So they're putting a lot of gaps in the coverage. They're putting a lot of sublimits on, for instance. And sublimits can really, you may think you're buying coverage, but if you end up with a $250,000 breach response sublimit or a social engineering fraud sublimit or some kind of business interruption coverage sublimit, you're not really getting the coverage you want. So you need to be very careful about that. The biggest issue, though, were the exclusions to avoid. And when I reference exclusions, it's both the explicit exclusions and the implicit exclusions, because the coverage grant itself doesn't provide the coverage. And just to give you some highlights of a few of the things that we've seen as we reviewed clients' cyber insurance policies that they think they have coverage that for various risks that we see that are actually not there or have gaps in them. I'll just touch on a few of them. One is a lot of the policies don't cover actions by rogue employees, and of course rogue employees are perhaps the most vulnerable area you have, since they're already in your system. A lot of them don't cover the use of personal computers and phones and policies where you have company BYOD programs in place. Some of them don't cover alleged breaches, and the cost of doing a forensic investigation when you've been told that there's an alleged breach is every bit as much expensive, if not more expensive, than an actual breach, because you're trying to prove a negative, and you still need to get in there and take a look at it. So you want to have that kind of coverage as well. Some of the policies require a failure of security, and I think what experts like you've heard from already today would tell you is that sometimes you can do all the steps that you take and be as careful as you can, and bad guys will still get in there, and it's not a failure of security. Moreover, you don't want to admit that you have a failure of security, because that would actually create a potential admission in your potential third-party liability cases that are brought later. Some of the policies don't cover PCI penalties, for instance. Some of them don't cover breach of contract claims. It's a problem when you have your client relationships that are contractual in nature, and then those clients want to get made whole. You might have some exclusions there. Many policies have problems with social engineering fraud if there's anything that's done outside of the use of the computer. There are cases, for instance, that talk about the fact that a phone call was also made, or things like that might vitiate coverage. So you need to be careful what kind of coverage you have for social engineering fraud. Extortion policy coverage, a lot of carriers are selling it, but some of them are selling it only for threats to do something as opposed to threats to not undo something. So in other words, they may the bad actor may be saying that we've already gone in your system, we've encrypted your data, we'll only unencrypt it if you pay us in some kind of cyber currency. And a lot of the policies won't cover that because they only cover threats to do something, not undo something. We want to be very careful in terms of the choice of vendors and choice of counsel. Some of the carriers are putting on requirements that you can only use certain firms, vendors that are beholden to the carriers, that have maybe not quite as much experience, that maybe don't have the quite same incentive, paid very little. We've been successful in getting those things negotiated beforehand, so we don't have the same problems. Acts of foreign actors. They have a lot of terrorism exclusions that would exclude anyone who does something who may be foreign trained, from Russia, North Korea, China, even if they're engaging in just commercial thievery. And I think that we be very careful in how we define those exclusions. So there are a lot of these types of coverage issues we need to take a look at, and you got to be very careful about if you're really going to get true coverage. And then the last thing is the application itself. The carriers, there's been a lot of litigation on that as well, and the carriers ask in some of these cases a lot of questions, and the clients have to be very careful not to answer those in absolutes in terms of whether the patches are always put on in a timely fashion, or programs and procedures and security systems are updated at all times, and best practices are engaged in absolute terms like that. So the application itself can be a source of vulnerability for whether the coverage applies, and needs to be looked at very carefully, and needs to be looked at by all elements of the company from the board on down to make sure that the statements in the application are consistent with the actual security plans and practices of the company. So I think the bottom line is boards are looking at this in every instance, and if they're not, I think that could potentially be a big problem. Boards are driving reviews of the vulnerability and extent of the cyber insurance coverage that companies have, and so what we're seeing is a lot of boards are reaching out to us and asking us to audit their cyber insurance so that they can be careful that they've got the coverage that they think they need to protect from the kinds of issues that we've talked about today. And I think that's all I have on insurance.
Okay. Let's move on to the next slide, please. All right. So, just to sort of wrap things up, it is so important to prepare in advance for cyber issues, and boards and senior management will be asking about proactive readiness. What does that mean? It means making sure you know what and where your sensitive data is, making sure you have a state-of-the-art incident response plan. This is a dynamic, living and breathing document. It is not a static document because the intruders, our adversaries, are not static in their techniques and their methods, and we need to continue to ensure that we're fighting tomorrow's battle, not yesterday's battle. We always want to practice our incident response plan, and we do that through tabletop exercises. Those are now very common, not just for senior management, but also for boards. We've probably done at least 15 or 20 for boards, in addition, of course, to those who will be in the trenches managing these sorts of events. Of course, making sure that your information security policies are up to date is critical, and continually assessing your technical protections also is critically important. Vendors are a huge source of risk, so we think hard about the three types of responsibilities that we have vis-a-vis vendors, and that is to do due diligence in advance, ensure that you have strong contractual provisions and with vendors with respect to security, and third, doing ongoing monitoring to ensure that they are in fact protecting the data in the way that you expect. Managing insider risks is always a challenge. Having an insider cyber risk program is critically important. Training and awareness is, of course, top of mind, particularly where social engineering is absolutely rampant these days, taking advantage of human tendencies, human vulnerabilities. Phishing is a type of social engineering that we're seeing in droves, and seeing very significant damage, very, very significant damage result from successful phishing attacks. And of course, assessing your cyber portfolio is the backstop to it all. Next slide, please. There is little question, of course, that cybersecurity is a fundamental governance issue from now, and focus needs to come from the top and needs to trickle down, and the attitude towards cyber needs to be set by those at the very, very top of the food chain. Boards should ensure that they're kept up to date. This should be a regular agenda item for directors. And the maturity of a program, as I said, with respect to the incident response plan, but the maturity of a cyber program generally needs to be constantly addressed. This is it's hard, and it is a never-ending battle, and just getting the environment is just getting more and more pernicious. So the battle is getting harder, and we need more foot soldiers. And certainly preparing for these events, preparing management, preparing the board will serve to mitigate harm ultimately if you're hit with a cyber incident. And it's certainly inevitable that every organization will suffer one. We are at time, so I'm going to wrap up the program. Thank you very much for joining us. We very much appreciate your attendance, and we will follow up with a recording. Please do visit Hunton's privacy blog at www.huntonprivacyblog.com for the latest developments in privacy and cybersecurity, and we look forward to having you at future events. Thank you. Bye-bye.